end of the channel. He assumed the Troll River would immediately turn out to sea. She didn't turn. Instead, she continued towards the end of the fairway. The Shavit cut across her bow, and the two ships collided. In court, the Shavit's owners were held to be solely to blame for the collision. Failure to carry proper charts had caused the accident, and this factor alone was considered to be more important than any other adverse circumstances at the time. The current collision regulations entered into force in 1977, with minor amendments in 1983. They were drawn up by the International Maritime Organization, the IMO, and they replaced the earlier 1960 collision regulations. The IMO regulations reflect the technical advances made in shipping in recent years and define the principles of good navigation, including provision for safe speed, maintaining a proper lookout, and the movement of ships in traffic separation schemes. They provide specific guidelines for situations in which collisions are most likely to occur. Of course, these are a standard part of a master's training. However, taking the right steps to avoid an accident cannot guarantee a safe passage. That's why a master must be prepared for the worst. He must know what steps should be taken after a collision has occurred, whether or not he is in any way to blame. The potential losses inflicted by a shipping collision can be many and varied. They may amount to far more than the repair of physical damage. Liabilities could arise from death or injury, claims by a crew for loss of wages or lost personal effects. There could be salvage claims, cargo claims, damages for detention during repair, and heavy fines. In a collision, some or all of these factors will be involved. So to protect his interests and those of his shipowner, the most important thing a master should do is get expert assistance as fast as possible. The principal characters in the subsequent drama are the hull broker. He is the vital link between the owner and the underwriters insuring the ship. The acting solicitor. His role can be crucial. He will gather the on-the-spot evidence which may determine the outcome of a court case months or years later. The average adjuster. He'll be required to assist the shipowner in presenting a claim to the hull underwriters. The classification society surveyor. Where the ship has sustained damage affecting seaworthiness, repairs need to be specified to put it back in class. The local P&I Club representative. For the master, the most crucial person to inform quickly, whether directly or via his owners. He is the man on the spot, and can therefore give immediate advice and assistance to the master. There is another vital reason why the P&I Club must be immediately involved. The P&I Club will normally cover 25% of a ship's liabilities to the other vessel, with the other 75% spread among a number of underwriters. The P&I Club, as, in effect, the single most interested party, will be responsible for posting a financial security to cover potential claims from the other ship. We shall see later the potential consequences of a delay in this being done. As soon as possible, the hull underwriters or the P&I Club, and sometimes both, will appoint a surveyor to assess the damage to the ship. The surveyor will also attend the other ship involved to note her damage as well. This is an essential protection against excessive counterclaims. A survey on the other vessel is generally known as a without prejudice or WP survey. It requires the permission of the other shipowner to go on board, but this is normally achieved by offering reciprocal rights of access to their surveyor. As well as establishing what damage has occurred, the surveyor can draw conclusions about the speed and direction of navigation before impact. This evidence can be central to deciding who's to blame. Most importantly, it reinforces the need for a master and crew to be entirely truthful about the circumstances of a collision. Any attempt to improve a record of the sequence of events is likely to be found out. This is not only because of survey evidence. All relevant documents are likely to be seen by the court, including the ship's logs, notes of protest, course recorder's charts, and traces. In all cases, it's up to the solicitor, with the help of the master, to formulate the best possible defense. If the solicitor is not told the complete truth, his advice and ability to conduct the case may be badly affected. The financial consequences of any fabrication could be disastrous. Two ships of a similar size are involved in a collision at Le Havre harbour mouth. The master of the first ship, the Extremis, contacts the Salvage Association representing the underwriters, but the P&I Club is not informed. The second ship, the Optimis, apparently only slightly damaged, sets sail. The Salvage Association surveyor assesses the damage to the Extremis, but is unable to conduct a WP survey on the Optimis as it has sailed. The owners of the Extremis then find that the Optimus has lodged a claim against them at Le Havre, and their ship, still in port, is arrested as security. Because the P&I Club had not immediately been informed, there is a delay in arranging financial security to get the ship released. Further, the master has handed over the relevant documents to a lawyer. This lawyer turns out to be representing the owners of the Optimis. Result: the evidence for the Extremis defense is with the other side. The owner has lost several days' operating costs while the ship was under arrest. This may be a hypothetical case, but it does illustrate what can go wrong if the right actions are not taken by master and owner. Collisions may be the most dramatic example of shipping misfortunes, but there are many other circumstances in which a vessel can be incapacitated. Mechanical failure, running aground, or extreme weather conditions may be the cause. In such cases, a master may have to consider an offer of salvage from another ship. The master has the power and authority to take whatever action he sees fit to save his crew, ship, and cargo. Although he will often have time to contact his owners for advice, in an emergency he may not. So a knowledge of the principles and procedures of salvage is important. The first requirement for assistance to be considered salvage is that a ship is in real, not imagined, danger. If a vessel is simply immobilized but not in danger, a salvage agreement should not be entered into. In such circumstances, it's clearly beneficial if a master can negotiate a daily rate for a tow. The cost or reward in salvage cases is much higher. However, even if the master has, with hindsight, mistakenly accepted salvage, the consequences of his misjudgment will be mitigated. The arbitrator will decide whether the ship was in real danger or not in deciding his reward, and the test is an objective one. Another requirement for salvage is that at the end of the day, some part of the ship or its cargo has actually been saved. If a salvage attempt is totally unsuccessful, no award will be made. This idea of no cure, no pay forms the basis of the commonly used salvage agreement, Lloyd's Open Form. It provides for a salvage award to be made by an arbitrator appointed by the Committee of Lloyd's. Masters should be conversant with the provisions of Lloyd's Open Form. When it needs to be signed, it's often too late. Of course, the form doesn't have to be physically signed by both masters before a salvage can begin. A verbal agreement to abide by its terms is all that is required. The form itself includes a clear provision for signing to take place during or even after the operation is complete. The master's power to sign a salvage agreement is based on his position as an agent of necessity. He is the man in a dangerous situation who has to take the decisions. He is agent of necessity for the cargo, but by signing the form, he is not accepting liability for its safety. This is because the single act of signing represents two separate agreements, one between the salvors and the ship owner, the other between the salvors and the cargo owners. The reason the master acts as an agent for the cargo owners is a practical one. It would not normally be possible to contact them, let alone negotiate a separate deal. Similarly, if security is required as a condition of salvage, the ship owner is only bound to provide his own share for his own property. Other shares must be provided by the cargo owners as appropriate. A master should always be prepared to enter into more than one salvage agreement if it will help to save his ship. There is no reason why he should sign only one agreement. He can contract as many salvors as he wishes. This may increase the cost of salvage, but it's the right course of action to take if the circumstances are sufficiently dangerous. However, A subsequent salvor cannot displace or dispossess an already engaged salvor without good reason. A good reason, of course, would be that the first tug was not powerful enough for the job. The master should be aware that if he hands over the job to another salvor without good reason, he could expose his owner to heavy damages to the dispossessed company. Once the salvage operation has begun, the master of the ship should give all reasonable assistance to the salvors. He should also keep highly detailed records of all events at the time. Because the award is decided on the basis of written statements, it's essential that there should be sufficient evidence to establish what actually happened. All records can have a bearing on the outcome. Logbooks, transcripts of radio messages, survey reports, or repair accounts may be important. It can be useful to make sketches and take photographs. It's on the basis of these documents that final written statements can be drawn up. The same advice applies to the master of any ship offering salvage, but there are some additional considerations. No master should hesitate to go to the assistance of another ship in distress. In fact, he has a duty to do so. But he should take steps to protect his interests in such unforeseen circumstances. He should always inform his owners of his actions. He should consider what the owner's position may be with regard to deviation, under the terms of a charter party or a bill of lading. He needs to assess the quantity of bunkers remaining and whether his ship really is suitable and powerful enough to offer genuine assistance. You can see that even in an emergency, whether the aftermath of a collision or a salvage action, the master has a clear commercial responsibility to help minimize the financial and other consequences of the unexpected occurrence. In the business of shipping, mistakes are a luxury no one can afford.